Hey everyone, and welcome to this explainer brought to you by We in Law, your civic education resource hub totally committed to enlightenment for development. Today, we're unpacking a really crucial topic, the legal pathways to parenthood in Nigeria. We're going to break down exactly what the Child's Rights Act actually requires when it comes to fostering and adoption. So whether you're thinking about opening up your own home to a child or you just want to understand the legal safeguards for society's most vulnerable, you are absolutely in the right place. Here's our quick roadmap for this explainer. We'll start with foundational principles, then walk through the path to fostering and the permanence of adoption. After that, we'll tackle parental rights and strict bans, dive into private fostering and relative care, and wrap the whole thing up with family courts, monitoring, and appendix details. All right, let's jump right into Section 1, Foundational Principles and the Sacred Duty to the Child. You know, before a single piece of paperwork is ever signed or a court order is issued, the law lays down a rock-solid moral compass. It states that the best interest of the child shall be the primary consideration in every action taken. It's a beautiful standard, really. It means the ultimate goal isn't just to grant the wishes of prospective parents. No, the absolute priority, trumping everything else, is protecting the child's well-being. Every single rule we're going to talk about today grows straight out of that one paramount principle. And that protection goes way beyond just food and shelter. The Act fiercely defends some core pillars of protection. First up, every child has the right to a distinct name and legal identity right from birth. Second, they have an inherent right to family life and parental care. But honestly, the third point is incredibly profound. The law strictly preserves a child's religious heritage. It mandates that a child's right to practice their own religion has to be a primary consideration. So transitioning to a new home must absolutely respect where that child originally comes from. Moving right along to Section 2, the path to fostering, or providing a temporary home. Fostering carries massive legal responsibilities, but it's typically a temporary setup. It's meant for a child who has been abandoned, abused, orphaned, or whose parents just can't provide proper guidance right now. And getting there involves a really rigorous 4-step legal process. You start with an application to the family court, and then you have to secure all the required consents, which includes getting your spouse on board if you're married. But step 3 is where things get really serious, the probationary test period. This can last up to 2 full years. During this whole time, a child development officer is actively supervising the placement just to make absolutely sure the environment is safe and nurturing before a final fostering order is ever granted. And speaking of making sure the environment is nurturing, the law enforces a really strict rule, a limit of 3 foster children per home. This ensures every foster child actually gets the dedicated time, resources, and attention they desperately need. Now, there is one major exception to this rule, and it's for siblings. The law heavily favors keeping brothers and sisters together, even if that means bumping you over that 3-child limit. Let's look at Section 3 now, the permanence of adoption, which is a lifelong commitment. So if fostering is temporary, adoption is the exact opposite. It completely, permanently changes the child's legal status. They become yours forever in the eyes of the law. Because this is a permanent, lifelong commitment, the prerequisites are incredibly strict to ensure maximum stability. You've got to have lived in the state for at least 5 years. The child has to have been in your continuous care for a test period of at least 3 consecutive months. On top of that, you have to give a 12-month advance notice of your intent to adopt to a social welfare officer. And finally, the court orders a deep, official background investigation into your life to prove you're a fit and proper person. To protect the integrity of adoptions, the law draws some absolute, non-negotiable boundaries. First, no unapproved payments or financial rewards whatsoever. Adoption can literally never be motivated by money. Second, there's a strict ban on taking an adopted child across state lines unless you get a special license from the minister. By the way, to make sure you never miss essential civic knowledge like this, go ahead and hit subscribe on the We in Law YouTube channel right now. Lastly, keep in mind that the child's original birth record will legally and permanently be marked with the word adopted. That brings us to Section 4, parental rights and strict bans, or stepping into the parent's shoes. Taking a child into your home means bearing the really heavy weight of parental responsibility, and the law handles this power shift very differently depending on which path you choose. It's a fascinating divide. In fostering, the biological parents' rights are merely suspended. You're temporarily stepping into their shoes to provide maintenance and education, but the original ties are just on hold. In adoption, though, those biological parents' rights are completely extinguished forever. The child is legally yours, and they even gain full inheritance rights to your property, exactly like a natural-born child would. And because you're taking on such a sacred family tie, the law protects it fiercely. Marrying a child you have fostered or adopted is strictly banned. Any attempt to do so is treated as a totally null and void marriage. But worse than that, crossing this line carries a massive 14-year prison sentence. So yeah, the law leaves absolutely zero room for ambiguity there. So far, we've focused heavily on formal court processes. But you might be wondering, what if you just make a private, informal arrangement? Say you agree to take in a friend's child for a few months to help out. Well, before we dive into how the government regulates these everyday placements, this is a great time to quickly remind you to subscribe to the We and Law YouTube channel for more awesome updates on your civic duties. Okay, so the law actually refers to these informal arrangements as private fostering. Here's how it works. If you care for a child under 18 for 28 days or more, and you are not their biological parent or a strictly defined legal relative, like a grandparent, sibling, aunt, uncle, niece, or nephew, then the law officially classifies what you're doing as private fostering. That 28-day mark is the legal trigger. And with private fostering, you absolutely cannot just do it in secret. You have a strict legal duty to notify the state government. Usually you have to do this 6 to 13 weeks before the child even arrives, or within 48 hours if it's a sudden emergency. Why? Because the state retains the power to inspect your home and literally prohibit the placement if they deem it unsafe. Plus, if you have a severe criminal record, or if a court has previously removed a child from your care, you are legally disqualified from private fostering right out of the gate. Let's look at Section 5, Family Courts and Monitoring, which serves as the ongoing safety net. Because here's the thing, the law doesn't just step away once the paperwork is signed and the child is living with you. It builds a massive ongoing safety net. All of these matters are handled by a specialized family court. And unlike your typical civil or criminal courts, these proceedings are held in absolute strict privacy. The public and the press are completely banned from attending. This is huge because it ensures your new family's private life and the highly vulnerable identity of the child are entirely shielded from public scrutiny. And to prove its dedication to the child's ongoing welfare, the state mandates really rigorous monitoring visits. For formal fostering, child development officers will conduct periodic visits right up until that child turns 18. For private fostering, the scrutiny is actually even tighter at the beginning. A state government officer has to visit within the very first week, and then at least every 6 weeks for the entire first year. As a caregiver, you have a strict legal duty to allow these visits and prove the child is staying healthy and getting a proper education. Finally, we arrive at Section 6, Appendix Details, covering practical forms and orders. To make all these profound legal concepts practically enforceable in the real world, the Child's Rights Act includes a highly structured appendix packed with legal templates and schedules. We're talking standard forms like committal orders and summons used to legally initiate court actions. But it also includes legally binding financial support orders, meaning the court can actually force parents to make regular, periodical payments based on their income to guarantee the child's maintenance. There are also supervision orders that task social workers to advise and assist the child's development. And crucially, there are official fostered and adopted children registers. These are highly confidential records. You can only access them with a specific court order, and they act as permanent legal proof of a child's status. We've covered a ton of ground in this explainer today, diving really deep into the frameworks designed to ensure every child's safety and dignity. I want to leave you with a provocative thought as you reflect on the profound legal responsibility demanded by the Child's Rights Act. As you consider opening your home, ask yourself, are you truly prepared for the sacred duty and the strict legal weight of stepping into a parent's shoes?